All right, I've read out this piece from Gary Judd on this remarkable decision from the Court of Appeal, which has overturned a High Court decision that the Minister of Children, Karen Chua, who wants to repeal parts of the Act governing the placement of children in state care, to have disregard, if you like, for their whakapapa, for their Māori heritage. And she wants the children to be the most important thing in any decisions made. Good call, I say. The Waitangi Tribunal heard a claim that was a breach of something, and they wanted the minister to appear to explain her position. A High Court hearing was heard where they were told they could not compel her to appear by subpoena, and the Court of Appeal has overturned that decision on appeal. It is all rather a moot point, as the Waitangi Tribunal's inquiry into the repeal of this section of the Act, of our laws, is over, and they've come out and said it's bad and it's bad policy and it shouldn't happen, which strangely enough isn't their job. And that piece by Gary Judd basically says it was never the tribunal's job. They're actually part of the executive branch of government, and they're there to serve the minister, not critique her. Is that a robust view that Gary Judd's got? And what the hell is up with our justice system and our judges? We are joined now by former MP, lawyer, free speech advocate, Stephen Frank. Stephen, how are you?
Very well.
I thought the Court of Appeal's decision today was stunning. Do we have a problem?
Yes, I mean, it's interesting. They're right in that the earlier decision, the judge, I think very wisely, was saying these institutions should express comity, that is, a mutual respect that says they try and stay out of each other's patch.
Yep.
And he reached that conclusion on the very common view that the Waitangi Tribunal, as a commission of inquiry, should be treated as if it were a court. The Court of Appeal says very firmly, no, it isn't, and that's what Gary Judd's been saying all along. So they're right.
It's not a court, it's part of the executive branch of government.
Yes, well, Gary's focus on that, I think in reality it's a sort of hybrid, but it is an advisor to ministers. It can make recommendations. They don't have to accept it. There have been rather silly reports from the tribunal that the government has rejected immediately. Helen Clark did that when they made an extraordinary decision that Māori owned all the oil and gas reserves. And so it is just an advisor, and it was getting way above.
It would seem to be a partisan advisor.
Yes, it's become that. I think when Eddie Jury was the president, the chairman, it was respectful and was trying to be a body that brought us together. It's now just part of the project to turn us into a country with uncertain sovereignty. And it's
right. Would you say, in the current context, the Waitangi Tribunal is the de facto Maori part of a bipartisan governance system? It's setting itself up as some sort of alternate power structure or authority in New Zealand.
I think it's a bit more complicated. It's also a branch of the attempt to lawyerise the country, that we should be ruled by lawyers in all sorts of guises. I mean, there's an awful lot of suspicion amongst lawyers of the rude and scoffing multitude we call democracy, and they feel that they're much wiser and that ruling should be
yes,
to them.
If only those troublesome little voters could have the level of education and intelligence that we have.
Yeah, and priests have ruled many societies. We've got rid of priests and we've got lawyers instead. But just to go back to it, the idea that a minister should be paraded in front of the commission, where undoubtedly that would be an exhibition of power, and that's the bit that the Court of Appeal should have jumped on. They should have also adopted the High Court judge's view that comity a bit of respect would have been in order here, but they don't. They go through and instead they elevate the role of the Commission. And sadly, they've got a good reason to do that, because Crown Law was also saying that the Commission was a very important part of our constitutional structure.
Whoa. Okay, sorry. Saying what was an important part of our constitutional structure? The Waitangi Tribunal? The
Tribunal, yes. Giving it a very... They were talking up the significance of the Tribunal and its role in a way that made it not easy for the court then to express wisely the view that to have your democratically elected minister paraded in front of a tribunal that is then going to give advice on whether the minister's policy, which they had as part of their election manifesto, whether that was a good idea or not. The court just doesn't even get there. Whereas the High Court Judge Isaac, was very conscious of that.
Yeah. Stephen, it seems to me we're getting into some quite dangerous territory here with the Waitangi Tribunal. And we need to have some boundaries, or we need to have some boundaries put around it, because this could end up in some very strange places.
Yes, well, remember though that the Supreme Court is also making stuff up as they go too. I mean, they've just suddenly announced that tikanga is part of the law of New Zealand and always has been. And in fact, it's the original law of New Zealand. And we don't even know what it is. It's custom. It's custom, just like all different peoples and groups and families have custom. And sometimes it should be significant and sometimes not. But to call it law when it's not written, it's not ascertainable, you can't know it in advance, you've got to go and find out after the act, is ludicrous. But that's being solemnly recited now by lawyers and judges all over New Zealand and giving them...
Well, not all lawyers and judges. Gary Judd's involved in that too, lodging the claim with the Regulations Review Committee that's wrong.
Yes, he's standing up for the conventional view of the rule of law.
Well, what if we don't have the conventional view of the rule of law, Stephen?
Well, you have an imperialistic or an activist judiciary, and it's the role of Parliament to smack them on the nose. It really is. It's well overdue. They should have been told quite bluntly by Parliament some time ago that they were getting out of their constitutional box.